Welcome. In this video, you will learn about the active efforts state agencies are required to make to provide services designed to prevent the breakup or reunify tribal families in Indian Child Welfare Act, or ICWA cases. Whenever a state agency or private party seeks the foster care placement of or termination of parental rights to an Indian child in state court, ICWA requires them to prove that active efforts have been made designed to prevent the breakup of the Indian family and that such efforts have proved unsuccessful. While state agencies are required to make reasonable efforts in non-ICWA cases, they are required to make active efforts to preserve and reunify tribal children with their families in ICWA cases. As required by ICWA, the Office of Children's Services, or OCS, must provide active efforts in child in need of aid cases. Others may assist with these efforts. It could even be you as the ICWA worker. Ideally, it will be a collaborative effort between the parties, but the ultimate burden to make active efforts rests solely on OCS. The Supreme Court of Alaska has distinguished these efforts. It describes reasonable efforts as simply creating a case plan and then requiring the parents to go through the steps of bringing that plan to fruition on their own. Active efforts require the state to create the case plan in addition to walking with the parents through every step of the plan to bring it to fruition. As the name suggests, the active efforts standard places a higher standard on state agencies like OCS to provide services to preserve and reunify tribal families relative to the reasonable efforts standard that applies to non-ICWA cases. By the plain meaning of the term, active efforts cannot be passive. Whenever possible, active efforts should be made to prevent the child from being removed in the first place, and the state should involve the tribe at every opportunity. These efforts should include resources like the child's extended family, as well as the tribe, and the services should be consistent with the social and cultural norms unique to the tribe. They are intended to be affirmative and thorough efforts that go above and beyond simply offering referrals to the family by actively engaging them in identifying, accessing, and participating in those services. A few examples of active efforts provided by the BIA include actively assisting parents in accessing services, inviting and collaborating with the tribe to plan and provide services to the family, conducting a diligent relative search to identify the child's extended family through members for potential placement, and supporting regular, virtual, telephonic, and in-person visits between the child and their parents. These efforts must be provided in all ICWA cases, and though the specific services the family needs may vary by case, there are no exceptions to the active efforts mandate. Even if one parent is incarcerated, OCS still must make active efforts to engage with that parent. Active efforts must be provided throughout the case prior to the termination of parental rights. ICWA also requires that OCS and the court document those efforts in detail and on the record, and to accomplish this, the state needs to ensure that when provided, there is enough documentation available for the court to conclude that active efforts were provided. The active efforts standard is the result of the U.S. Congress finding that tribal families were being broken up by the removal of their children by public and private agencies at a much higher rate than non-Indian families, often when the removal was not justified and they were being placed in non-native adoptive homes or institutions. Congress found that the state agencies were not culturally competent in assessing tribal families, and the social and economic conditions in Indian country often favored the removal of those children when assessed according to Western standards. For example, state agencies failed to recognize that having children cared for by their extended family members is a cultural norm for many tribes, but by Western standards, it was wrongfully framed as abandonment by the parents. Ultimately, Congress recognized that there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children. The active efforts standard is in place to prevent the rampant and unjustified out-of-home placement of tribal children that continues to take place despite the enactment of ICWA. At every hearing in which the court may authorize the removal of an Indian child from his or her parents, the court must enter findings that the state has made active efforts to provide services to try and prevent the breakup of the family as required by ICWA. If the tribe believes that the state is failing to make active efforts as required by ICWA, then you should object to the court making those findings. Should the tribe choose to do this, it must prepare to argue why active efforts have not been made and what must be done to make them. While the finding that active efforts were not made will not result in the children being returned and the case dismissed, it should result in the court ordering the state to make those efforts and may result in a loss of federal funding. Until the court finds that the state has made active efforts, it will have to postpone entering a disposition order. This is when the court must decide whether to commit the child to the custody of the state for up to 2 years, or if it will release the child from state custody. Should the state continue to fail to meet its burden of active efforts, the court could sanction them, but this would be a last resort. In this video, you have learned about the active efforts that public and private entities must make in ICWA cases involving the out-of-home placement or termination of parental rights to tribal children. The active efforts requirement reflects Congress's recognizing the harm inflicted on tribes by the rampant and unjustified removal of tribal children from their families. Consequently, state agencies must ensure that tribal families receive the services they need for their children to safely remain in their homes or to return home if removed. As the ICWA worker, the state should collaborate with you at every opportunity. The parties and the court will turn to you for guidance on providing engaging and culturally appropriate services to the family. If the tribe does not think active efforts are being made, then you as the ICWA worker should make your voice heard by objecting to the court making those findings and explain the tribe's position on what the state needs to do to make active efforts.